My name is Deputy President Reg Hamilton. I'm a member of the Fair Work Commission and the Commission's archivist. I would like to set the scene for you for this most significant event, the hearing of the Harvester case. The year was 1904. Victoria's population was just over 1.2 million. Fitzroy beat Carlton in the VFL Grand Final. Dame Nellie Melba had just finished a tour of Australia and New Zealand, and the federal government under Australia's second Prime Minister, Alfred Deakin, introduced the Commonwealth Conciliation and Arbitration Act 1904 and constituted the Arbitration Court, or known as the Commonwealth Court of Conciliation and Arbitration. Meanwhile, there was state legislation. The Victorian Factories and Shops Act 1896 set up Wages Board in 6 industry sectors to set minimum wages. In September 1904, the Iron Moulders Wages Board set minimum wages and also established a ratio of men to boys, boys being cheaper to employ. The determination affected iron moulders in cities, towns and boroughs. The determination would come into operation from 1 October 1904, but before it could come into effect, Mr. H.V. Mackay, an inventor, industrialist, and the owner of the Sunshine Harvester Works, closed the factory in the city of Ballarat. Between 500 to 600 workers were stood down. Mr. Mackay told the Victorian Premier, the Honourable Thomas Bent, that the deplorable part of the present difficulty was that the steel factory and the malleable iron foundry, which were initiated at heavy expense, were now idle, and unless the Wages Board's restrictions were removed, he would have to revert to the old method of importing parts to be constructed in the foundries. In 1906, Mr. Mackay decided to move the Sunshine Harvester Works operation to its branch factory in Braybrook, which coincidentally was not covered by the determination. In August 1906, a deputation of iron moulders complained to the Chief Secretary and Minister for Labour, Sir Samuel Gillett. They said that Mackay's Sunshine Harvester Works were not working under the Wages Board determination. The deputation told the Chief Secretary that while the determination provided that there should be only 1 boy employed for each 2 men, at the Sunshine Harvester Works there were 6 boys to 1 man, and boys being cheaper. The deputation suggested that Mr. Mackay only moved the Sunshine Harvester Works to Braybrook to avoid the Wages Board determination, which could not be enforced as it did not apply in the Shire of Braybrook. The deputation gave Sir Samuel Gillett a petition signed by 100 iron moulders demanding that the Wages Board determination be extended to iron moulders working in Braybrook. However, in October 1906, the federal government under Prime Minister Alfred Deakin introduced 2 bills which eventually became the Customs Tariffs Act 1906 and the Excise Tariffs Act 1906. This was part of the government's new protection policy, under which companies would receive tariff protection from overseas competition if workers were also protected. These acts were complex, but the practical effect was that if a local manufacturer wanted the full benefit of tariff protection, it had to apply for and obtain a declaration by the Arbitration Court that employees were paid a rate of remuneration which was fair and reasonable. The Customs Tariff Act imposed import duties on agricultural machinery. The price of a stripper harvester was around £70, and the duty payable from 7th October 1906 was £12. Complementary to this measure was the Excise Tariffs Act 1906, which imposed excise duties equal to half of the import duties. So a lot of money was involved in this issue. In June 1907, Justice Richard O'Connor, the first president of the Arbitration Court, dealt with a number of applications under the Excise Tariffs Act. One of these cases, Bagshaw, was settled by agreement, and a minimum unskilled wage of 6 shillings and 6pence was set, with higher amounts for skilled men. Justice O'Connor then approved the applications of 108 manufacturers whose wages met the Bagshaw standard. Later the same year, Mackay, along with 111 other Victorian manufacturers, applied to Justice Henry Higgins, the second President of the Arbitration Court, for a certificate of exemption. Mackay's application was selected effectively as a test case because the Sunshine Harvester Works factory was one of the largest in the state, had the greatest number and variety of employees, and because the application would be keenly fought. There is no indication that Justice Higgins ascribed any persuasive authority to the Bagshaw precedent. The Harvester hearing began on the 7th October 1907 and finished on 1 November. The decision was handed down on the 8th of November, a week later. As we will see in tonight's mock hearing, there was nothing to suggest that there was any prior intention of treating the living standards of employees and their families as an issue. The union's representative wanted Justice Higgins to take into account the profitability of Mackay's business and to give employees a share of that. Justice Higgins insisted on the priority of the cost of living, and this seems to have forced the parties to review their positions. The manner in which the evidence of living cost was given, mostly by the assembled trade union leaders and a few of their wives, suggests that calling this evidence was something of an afterthought. Tonight, we revisit the Harvester case before a full bench of the Fair Work Commission, the descendant body of the Arbitration Court. We will hear evidence from an amalgam of some of the original witnesses from 1907, with some artistic licence, to create Harvester Revisited.
Please be seated. Welcome to the Fair Work Commission's reenactment of the historical Harvester case of 1907. Tonight's proceedings are being live streamed and recorded. An edited copy of the recording will be available on the Commission's website in due course. The roles of the witnesses in tonight's events are being played by Commission staff, and the parties are represented by leading counsel Rachel Doyle and Frank Parry. Thank you all for your interest in this event. I hope you enjoy the proceedings. Call the matter on.
This is an application by H.V. Mackay for an order that the remuneration of labour paid by him is fair and reasonable under the Excise Tariff 1906.
Could I have the appearances, please?
Yes, may it please the Commission, my name is Doyle, initial R. I've been briefed by Mr Duffy on behalf of the following unions: the Agricultural Implement Makers Society, the Amalgamated Iron Moulders, the Amalgamated Iron Foundry Employees, Tinsmiths and Ironworkers Society, and the Ironworkers Assistance Society. May it please the Commission.
Thank you, Mr Doyle.
The Commission pleases here for the Mr H.V. Mackay of the Sunshine Harvester Works. My name is Parry F, if the Commission pleases.
Thank you, Mr Parry. This is an application from Mr Mackay of the Sunshine Harvester Works for a declaration under the Excise Tariff Act of 1906 that the wages paid in his factory are fair and reasonable. The first difficulty that faces us is the meaning of the Act. The words are few, and there's no clear indication as to what is meant by fair and reasonable. What then is the model by which fairness and reasonableness are to be determined? Mr Doyle.
Well, first, if the Commission pleases, I wish to make application for the production of the factory's books. It's essential for this inquiry that we have the information contained in those books of account.
Mr Parry.
The only books relevant to this inquiry are the wages books. We use them daily at the Sunshine Factory. They would be very inconvenient to bring to Melbourne. Perhaps Ms Doyle could travel down the Calder Highway and attend the factory and inspect the books there. If she so wishes to do that, then we will make the necessary arrangements. if the Commission pleases.
I need to clarify whether Mr Parry refuses to produce the books connected with the cost of manufacturing. I'm advised that these are relevant, and I'd remind him and this Commission that Mr Justice O'Connor in Bagshaw's application ordered the employer to produce the previous year's balance sheets.
Well, the position of Mr Mackay is that he regards it as utterly unreasonable a demand that he produce his books and balance sheets, and has declined to do so.
So, Mr Parry, are you saying Mr Mackay has no objection to producing the wages books, but will not produce the financial books?
Well, quite. He apparently will allow us to interrogate the wages, but not the very thing we need to see, the proof of costs of production.
Ms Doyle, are you saying that you want to know the cost of production in order to show that Mr Mackay is able to pay higher wages? Supposing Mr Mackay says, yes, I'm prepared to pay good wages, whatever that may be, then surely the books are not relevant.
It is that, but there's a more important point behind it. The Customs Act was originally brought in for the purpose of protecting the interests of the manufacturers, the farmers and the employees. But on the same day, there was an Excise Act also enacted, specifically for the protection of the workers. Now, this Commission is now entrusted with interrogating the question whether those wages are fair and reasonable. This necessitates us looking into the profits obtained, because the court needs to ask, is the relationship between the employer, Mr Mackay, and his workers one which is fair and reasonable? In order to look at that balance, we need to look at the profit margin, which will only be exposed by looking at the books. One of the conditions, which would be fair and reasonable, would be whether the amount of money paid out of those profits is fairly divided between the employer and the employee.
But supposing Mr Mackay says, I'm making a good profit and I'm able to pay a reasonable wage, but I believe that I'm already paying it.
The difficulty with that, if the Commission pleases, is that it means that a certificate will not be granted unless it appears that there's a reasonable distribution of the profits. We're not going to know what's reasonable until we see what those profits are.
The Commission pleases. The exposure of a man's financial position may well play into the hands of his competitors.
We agree, Mr Parry. There must be cards on the table for all sides or for none. We would be wary of making one company's financial position known to its competitors. We think that perhaps the better plan is for us to say at this stage that we will not order the production of anything.
With respect, if the Commission pleases, it's appreciated that if the balance sheets are produced, it may do some harm to the firm's interests. But the real thing that needs to be inquired into here is the whole of the circumstances regarding what profits are made by the masters, and also whether the wages given to the employees form a reasonable proportion of that profit. And without that access, we have nothing to go on.
Mr Doyle, are you saying if there is a poor and unprofitable employer that we should allow them to pay lower wages? Or perhaps put another way, do you think there should be a lower standard for a poorer manufacturer than for a wealthier one?
I do not suggest that for a moment, and we accept that it would be unfair to impose on the employer any conditions which would be likely to injure him in terms of his competitors. But it is of the first importance to determine what a man or a factory is making, so that the reasonableness of what he is going to give his workers by way of pay can be considered. And surely it is not enough in that circumstance to pay a man only the money required on which to exist.
So, Mr Parry, just to confirm, you do object to the production of the balance sheets?
Yes, we do so object. They're asked for with the sole object of discovering what profits are made by Mr Mackay. The position we take is that Mr Mackay is in a position to pay fair and reasonable wages, and further that he does so pay fair and reasonable wages, and it doesn't depend on the profits or losses that he makes. There's been no suggestion made that the men working there cannot live comfortably on their current wages.
Perhaps if we go to that matter, Ms Doyle, and put you on notice that you may be approaching this from the wrong direction. You haven't opened your case with any mention of the employee's actual wages and whether they are appropriate, given that the relevant inquiry for us is what is a fair and reasonable rate of pay. Given that, we'd like to know what food, clothing and accommodation can be had for employees earning a certain wage. Mr Parry, we believe Ms Doyle is right in saying that fair and reasonable is not merely the wage on which a labourer can live.
Ms Doyle, will you be able to provide any direct evidence from a workman's wife or housekeeper?
Well, I've just made those inquiries, if the Commission pleases, and we are going to call workers. We're going to call workers and their wives in order to give evidence about the cost of living and the way in which they make ends meet.
Thank you, Ms Doyle. Well, it appears that the provision of the Excise Tariff Act for fair and reasonable remuneration has been designed to benefit the employees working in the industry. Presumably, it must have been included to achieve something which the employees could not get by the ordinary system of bargaining with their employer. When we say fair and reasonable, though, it must mean fair and reasonable according to some standard. But what then is that standard? Yes, Mr Parry.
Your Honour, as the applicant in this proceeding, the employer, it's a difficult burden to place upon such an employer to say that he should say what the cost of living should be for an unskilled labourer.
But yes, Mr Parry, but surely it'll be as hard for the employer to give that evidence as it is for the employee.
Well, I'll leave that to Ms Doyle, given that she seems enthusiastic to be calling somebody from to give that sort of evidence.
Well, I didn't say that, Mr Parry. I said we would call workers and their wives who would attest to their experience of the cost of living. I mean, I must say I see a great difficulty, almost an impossibility, in us being required to produce evidence writ large as to the cost of living. That sort of information simply isn't available. But what we can and will do is bring evidence from individual workers from the factory, from different trades and different skill levels, and their wives, who will attest to their experience, their individual experience of making ends meet.
We admit there are difficulties, but it cannot be helped. What other basis than the cost of living would you suggest for an unskilled worker?
Well, we would say that that's hard to say, but that the basis to fix wages would be to see whether the rate currently paid to the unskilled labourer is in accord with rates usually paid and accepted.
No, Mr Parry, I don't think that will do. If the Act had meant to leave it to the individual employee to make the best bargain they could with their employer, then they would not have needed to have had this provision about fair and reasonable wages. The basic matter is what is necessary for the ordinary unskilled worker to live? What is fair and reasonable so that the worker may live and engage in a civilised society? We would like to know what the cost of living is to meet the normal needs of the average employee. Perhaps in this case we should hear from the employees first. Ms Doyle, if you can call your first witness.
Certainly, well, taking that indication from the bench, we will call an employee first. And I call first Mr Frederick Keating.
Please state your full name and address.
Frederick Keating.
Your address, please.
Sunshine.
Please place your right hand on the Bible. Do you swear by Almighty God that the evidence you shall give in this matter before the Fair Work Commission will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr Keating, we understand that you're nervous, especially being called to the box at such late notice. Just try if you can to assist the Commission, who are inquiring into the state of affairs at the factory you work at. Mr Keating, can you tell the Commission what your role is at the Sunshine Harvester Works?
I'm a blacksmith.
And are you a married man, Mr Keating?
Yes.
How many children do you have?
7, 5 alive.
Where do your children live?
My oldest 2 boys are still in Ballarat. The eldest is an apprentice at a flour mill, and the other is on a merino farm.
Does the family find it hard, the children being so far spread like that?
Yes, it's quite hard. We don't get to see the boys as much as we'd like to.
Now, I understand you moved to Melbourne for work. You moved from Ballarat to Melbourne.
Mm-hmm.
Did you work at the factory in Ballarat before it was shut down?
Yes. Yes, I did. However, after it shut, I was out of work for 4 months. For a short time, I had some work at Harrison's, but when we had to move to Melbourne to seek regular work once my wife became pregnant.
Now, sorry that I'm forced to pry, Mr Keating, but can you please assist the Commission by telling it what your weekly wage is?
My wages are 54 shillings.
Have you prepared a list where you've set out your budget and your weekly cost of living?
I have prepared a list, and I've had some experience in housekeeping as well.
Housekeeping, how is it that you've come to have experience in housekeeping?
Well, since I've been married on each of my wife's confinements due to pregnancy, not being in the position to keep a nurse, I have to do the housework and look after the children. My wife has been an invalid after the birth of our last child 5 months ago, suffering from a hemorrhage. During the whole of that time, I've been looking after the money and providing for the children and purchasing all the requirements of the house.
Goodness, I can only imagine how difficult it must be to have to look after all of the requirements of a house.
Very.
Have you had any help with that?
My wife's sister came down from Ballarat to help out for the first 2 months, however, she did have to return home.
And the list, do you have it there?
Yes.
So you say it was produced drawing on your own experience and with some help from your wife.
The list is produced up from my own personal experience, but I consulted my wife as well.
Could you read the list to us so we can understand the expenses listed there?
Yes. Rent is 7 shillings, groceries 13 shillings, meat 8 shillings, milk 3 and 6, bread is 3 shillings, vegetables is 2 and 6, fruit 1 shilling, tobacco is 1 shilling and 5 pence. The hiring of a sewing machine is 2 and 6, boots are 3 shillings, clothes are 4, medicine is 1 shilling, insurance is 5 pence, the union is 6 pence, the clothing club is 1 shilling, and wood is 3 shillings.
And that's something you and your wife have put together thinking about your expenses over the year, is that right?
Yes.
So can you tell us what an average week would cost you to keep your family housed and fed and clothed?
£2.12 and 10.
Now it says there in the list you read out that you only pay 1 shilling for medicine, and yet you said your wife was an invalid. How's that?
Well, yes, you see, we can only afford to pay for some of the bills my wife needs, with both the doctor for her and the baby. Sometimes we have to choose between the food for the children or the medicine.
You mentioned insurance of 5 pence. What's that for?
The insurance is shop insurance against accidents whilst working, though I'm not insured against death. We just can't afford that.
What of any amusements or pastimes? Is there an allowance for that in your budget?
No, I can't say that I enjoy myself much.
Oh, what about less regular costs then, Mr Keating?
I've allowed nothing to replace furniture, but when I want to go in for a little furniture, I have to strain to a point as to other articles in the list. I have to cut the living expenses down.
Now, is there anything else you haven't included in there?
I haven't included crockery. As you know, a large family breaks a good deal of crockery.
While you have that there, I'll just ask that that list be received as an exhibit by the Commission.
Thank you. We'll mark that as Exhibit A1.
Thank you. While that's being marked, Mr Keating, can you tell the Commission a little about your house?
Sure. The house I live in is very undesirable, but under the circumstances, it's all we can get. It's a 4-roomed house. That includes everything. It is of brick. The yard is on the small side for the number of children I have, and the rooms are very dark. We have no bathroom. We have a big tub out the back, and I tub them all on Saturday nights.
Well, can you tell us anything else, or is there anything else you want to say, Mr Keating, about your wages and the cost of living?
I just cannot live on £2, 14 shillings to keep my wife and family as they should be, and as I want them to be. I find it necessary to supplement my income. I occasionally earn some extra money outside of work in a billiard room as a marker. It's a harder life than what it should be.
Indeed. Thank you, Mr Keating. You just wait there, Mr Parry. We'll have some questions for you.
Aaron?
Good afternoon, Mr Keating. Firstly, I was wondering how you find the time to attend a billiard room, given all your other responsibilities.
I've done some marking after knocking off of work, but only when my wife is feeling better.
And the list you've provided to the Commission includes the rental of a sewing machine. Is that necessary?
Yes, I find the sewing machine an absolute necessity. Before the birth of my last child, my wife took in sewing regularly. She can only do so now when she's fit enough. We need the extra income.
What about the clothing club? What's that about?
This is the only method I have of getting a suit of clothes.
And you mentioned money for boots each week. You must do a lot of walking.
Yes, to and from work. But I'm not sure how my wife worked out boots at 3 shillings a week. I could not say how much was spent on boots last year.
Well, how's that?
Well, I wear out 3 pairs of working boots a year. They cost me 6 shillings and 6 pence a pair. Then I have Sunday boots. I wear them every night and on Saturdays and Sundays. I suppose I would wear out about 2 pairs per year, and they cost 10 and 6 a pair. Then the boots would have to be repaired, half soled and healed. I get each pair of the boots mended twice before throwing them away. My wife would wear out 3 pairs of boots a year, and then there are the children. The youngest had 7 pairs last year. Some of them are almost made of paper.
Now, Mr Keating, you say you have no time for amusements.
Well, I used to go to the football regularly, but after the birth of the baby, that's no longer possible.
You take no liquor.
No. On the rare occasion I find myself with a beer, however that's not so regular to be included on the list.
Thank you, Mr Keating.
Thank you for your evidence, Mr Keating. Your next witness, Mr Earl.
Yes, the next witness I'll call is Mrs Mary Russell. She's the wife of Ted Russell, who's an iron moulder at the Sunshine Harvester factory. We call Mary Russell.
Please face all bench. Please state your full name and address.
My name's Mary Russell. I live in Arden Street, North Melbourne.
Please place your right hand on the Bible. Do you swear by Almighty God that the evidence you shall give in this matter before the Fair Work Commission will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mrs Russell. As I've explained to the Commission, your husband, Ted, works at the Sunshine Harvester factory. Can you tell the Commission what your husband's role is there?
Yeah, Ted works as an iron moulder at the harvester. It's heavy and hard work for him. He's been doing that work for 4 years, but he started at Sunshine last year.
And what did he do before that?
Before that, he was working on the wharves, where he earned even less than he does now.
Well, please excuse the question, Mrs Russell. I don't mean to pry, but what was your husband earning at the time he worked on the wharves?
It was only 36 shillings a week back then.
How did you cope?
Well, we had to live very economically. It cost all my husband earned just to live, and sometimes more, so he ran into debt. We had to do without a lot of things back then.
Can you tell us what your husband earns now that he's employed at the Harvester Works?
Well, I'm not sure what he earns, but he gives me £2 10 shillings a week, and I spend it all.
And how do you find that, Mrs Russell?
Well, it's not enough to keep the family going. I could always do with more. I don't run into debt these days, but I spend it all, and I never have anything left over.
Well, tell us a little about how you manage.
Well, there's a good many days on which Ted never tastes meat. Sunday's the only day on which I make sure we can all enjoy that luxury. In an average week, my husband would probably only have meat on 3 days, and then it's only once a day.
What would you eat instead?
Well, we have bread and butter and porridge and anything else I could make cheap. We have porridge for breakfast. I'd give him vegetables, if I could get them, but we never have fish. Oh, it's so dear. Fish isn't a poor man's dish.
Have you prepared a list, Mrs Russell, so that you can tell us about what you spend each week?
Yep. Our weekly expenditure varies a bit, but I've made out a list just to give you an idea.
Well, perhaps if you take us to the list, walk us through it, tell us what are your weekly expenses.
Sure. Rent is 11 and 6, lodge is 1 shilling and 3pence, fires 3 and 6, milk 3 shillings, meat 5 shillings, groceries 12 shillings, the papers cost 6pence, vegetables 2 shillings, bread's 5 shillings, Ted's fares to and from work is about 1 and 6, boots and clothes 2 shillings each, and then school needs is probably about 6pence a week.
What's that as a total, Mrs Russell?
I think that comes to £2, 9 shillings and 9pence.
And that leaves you?
About 3pence.
3pence. Not much. How do you find the cost for other expenses? What do you do?
Well, occasionally if I have a shilling or two over, I might be able to get an odd pair of boots for the children now and then, but even at the best of times, it's only a shilling or two here and there.
Mrs Russell, I'm sorry, I should have asked you earlier. How many children do you have?
We have 3 children. The youngest starts at school next year, but as the children get bigger, the more it costs to keep them.
Now tell us a little about the house you mentioned. You said at the outset you live in North Melbourne.
Yeah, we live in North Melbourne now. It's a 4-room brick house, but it's not a very good house. There's 2 bedrooms, a living room and a kitchen, but we haven't got a bathroom. There's only a bath and a copper out in the yard, in the shed. We've never been able to replace any of our furniture. We've still got the same stuff we had when we got married.
Well, one of your highest expenses is rental. Have you tried to find perhaps a cheaper home?
Oh, I have, but the rents just keep increasing. I've been looking for a cheaper house for the last 6 months, but I can't get one, so we need to stay where we are. But even if the rent was a bit cheaper and the house is further away from Sunshine, then it'll cost more for Teddy and fares, so you can't win.
And I can only assume you haven't been imprudent enough to attempt to buy a house in Melbourne.
Kidding.
Is there anything else you'd like to say about your cost of living?
Yes, well, just our everyday necessities just keep increasing in price. Kerosene's gone up now, meat's considerably advanced in price, and we can never afford to go for rump steak these days. We used to buy stewing steak at 3.5 and now it's 4. So as a result, we find ourselves having to go in for less. It's often hard to make ends meet. And also, my husband's not insured. We can't afford to pay that cost. And if anything were happened to poor Ted, we'd have nothing.
Thank you, Mrs. Russell.
Mr Parry.
Commission pleases. Mrs. Russell, you said before starting work, your husband worked on the wharves and earned 36 shillings a week.
That's correct, sir.
You ran into debt. What happened?
Well, we had to do without.
Well, can you explain a bit more than that?
Oh, well, we let the tradesmen run up accounts. I paid them off the best I could, but we also had to go without many a thing to pay that debt off. The children often went barefoot in those days.
And have you paid it off?
Yep, eventually. It took a few years to pay off the bill, but I found that if you pay off so much each week, they'll let you run up a bill. Any man, if he sees that you're honest, he'll let you. I was pretty well trusted.
And how did you manage?
Well, it was a case of being careful and keeping your nose to the grindstone, year in and year out. It's just something we've become quite used to.
You said your husband often did without meat. Was this when he was on the wharves, or is it now at HV Mackay?
Well, when he worked on the wharves, my husband often went without meat. These days we can't afford enough every day, but probably 3 times a week, like I said before. Depends on the price. Sometimes I can get a bit of old mutton, but only if I can afford the price.
So what does your husband eat when you can't provide meat?
Well, he has whatever's in the house. Bread and butter, a bit of jam, vegetables if I can get them cheap.
Well, what did he get to sustain him during the day beside porridge and so on?
Well, nothing, I suppose.
Also, Mrs. Russell, you said you have moved house twice in the last year or so. Why is that?
Well, the house we were living in previous to the one we're in now, I was paying 10 shillings a week, and then the landlord raised it to 12. The rents just keep going up, and the houses of any kind are pretty scarce. So we have to live in this house because I can't get another one. I'd really like to get a better house with cheaper rent so we can allow us more for clothing and boots.
Thank you, Mrs. Russell.
Thank you for your evidence, Mrs. Russell. Any further witnesses, Mr. Orr? Mr. Parry?
The Commission pleases the evidence that I propose to call today in regard to the question of fair and reasonable remuneration is the evidence of a person in Mr. Mackay's employment. Mr. George Mackay, at the bar table with me, has for some years been the manager of the establishment. He is the person best acquainted not only with the general working of the department, but also with the personnel of the men there. He is the gentleman who engages the men and who fixes the rates of pay to be awarded to them. He is to a great extent actuated by the industrial capacity shown by the men. I call George Mackay.
Please face the full bench. Please state your full name and address.
George Mackay, 97 Winnows Street, Sunshine, Victoria.
Do you swear by Almighty God that the evidence you shall give in this matter before the Fair Work Commission to be the truth, the whole truth, and nothing but the truth?
I do.
If the Commission pleases, Mr Mackay, can you please tell us what your role is at the Sunshine Harvester Works?
I am the factory superintendent.
And how long have you been in that position for?
9 years.
The business that's carried on at the works, what is it?
We manufacture stripper harvesters.
And could you assist the Commission in describing what stripper harvesters are?
Certainly. It was something that my brother invented. Another brother of myself and I, constructed the first design. Essentially, Hugh, my brother, hate winnowing. So he designed a combine harvester that both strips and winnows the grain, making it ready for bagging.
Now, the manufacture of these harvesters, how is that carried out at the works?
We carry out the same work year in, year out. Each stripper harvester is made alike. It's not a shop where all kinds of work are carried out and men must be capable of giving attention to and doing various kinds of work. A great extent of the work throughout the whole establishment is not of heavy character, as has been stated, nor work requiring a great deal of skill.
And you yourself, Mr Mackay, what experience do you have of this kind of work?
My father were a family background. I completed an ironwork apprenticeship with House Brothers in 1885. After completing my apprenticeship, I went into business for myself, building coaches for 5 years. When Hugh established himself at Ballarat, I joined him there as a journeyman for 5 years, and then I became, in my present role, the factory superintendent.
And how long have you worked for your brother?
Almost constantly since 1888.
And your duties as superintendent?
As you said, to superintend the factory and fix the wages.
Now, Mr Mackay, could I ask you something about the men that work at the works? How many are there?
The returns show 495 men.
And the hours that they work?
The men work just 48 hours a week.
Can you tell the Commission how these hours are made up?
Work starts each weekday, commencing at 7:40 a.m. and continues on to lunch at 12:15. It starts again at 12:54 and we close at 5:05. On Saturdays, the work commences again at 7:40 a.m. and continues on to 11:50 a.m.
Are these hours fixed to suit the employees who come in by train to the works?
Yes, that is correct. They're fixed for that purpose.
And during your experience at the factory, what is your opinion as to whether the men have been satisfied with the wages paid?
Commission, please, as I object to that, this witness has a lot of skills, but he can't read the minds of the workers. He can't give evidence in relation to their level of satisfaction.
Objection upheld.
I was trying to see if they made any complaint. I will ask you this question, Mr Mackay. During your experience there, has there been any strike?
There has been no strike.
Now, this application before the Commission for the declaration, has a notice of that been posted in the factory?
Yes, it was kept posted for a week prior to the application.
Were there any complaints made by any of the employees?
No more than usual, no more than ordinary times.
Well, has there been any complaints since the notice was posted that the rates of wages paid in the factory are not fair and reasonable?
Men may have asked me for an increase of wages.
How many?
That's a rather difficult question. I cannot say how many. May I say some men have asked for an increase in wages?
And you don't have any idea how many there were?
Honestly, I cannot say.
Mr Mackay, can you tell me in regard to the men employed in the factory whether many of them, or indeed any of them, have been employed in the factory for a long time?
A good many of them have been employed for a good many years.
Can you tell the Commission when the factory was removed from Ballarat, did the workmen go down to the new factory or did they leave?
They came down with us, almost every one of them, and they've stayed.
So, Mr Mackay, can you tell us why the factory was moved from Ballarat to Sunshine?
Well, Your Honour, I do not conduct the whole business.
Very well, Mr Parry, please continue.
Mr Mackay, if I could turn to the wages that are paid to the workers, Mr Mackay, can you please tell the court, in regard to the wages of the employees you fix, how do you arrive at the amount of a man's wages?
Partly by the recommendation of the foreman in the various departments and partly by my own observation, I judge the value of the work and the principle of labour.
Do you find much or little variation among the workmen?
I find a good deal of variation.
Now, I'm going to ask you now something which may be difficult to determine. You mentioned yourself you'd worked as a journeyman. What do you understand by the word journeyman?
That means a competent tradesman, a man who has arrived at the standard of efficiency of his trade.
Thank you, Mr Mackay. What is your idea as to the meaning of the word improver?
What I call an improver is a person who has had some previous experience but has not yet obtained the sufficient skill to be a journeyman.
Well, what would you call a man who has no experience in the trade? Would you call a person who has no experience an improver?
No, that would be a labourer. A prover must have some experience.
I see, Mr Mackay. So you say there's no age limit for an improver? Can a man, say, of 30 years but can still be considered to be one?
Your Honour, I understand the Wages Board does not recognise any man who is over 21 as an improver, but what I call an improver is someone who has some experience but not up to the required standard.
So I see, Mr Mackay, you're saying from your point of view at least there's no age limit for an improver?
I do not think so.
Mr Mackay, can you tell the court about the labourers that you have working at the factory? What are they paid? And not here the journeymen or improvers.
So we have approximately 31 men who are employed as labourers doing unskilled work, and the wages we pay to them, we think, are reasonable compared with the other wages that are fixed. There are 27 men and 4 boys employed. They get sums, my records show, from 6 shillings to 7 shillings and 8 pence per day, according to their respective capacities. There is a labourer under 21 years of age at 7 and 14, and a boy of 17 at 3 and 9. We also employ 2 dray drivers who are under 21. They both get 4 and 2 a day.
Mr Parry, do you know what's paid in other industries?
Well, Your Honour, for the purposes of comparison, you might look at the confectionery board. The determination of that board is that labourers get a minimum wage of 30 shillings per week, so that is 5 shillings per day for the same number of hours.
Can you tell us what the confectioners' labourers do, Mr Parry?
Well, I do not know the answer to that, Your Honour. I suppose they carry boxes and materials from place to place. I don't suppose there's a great distinction between the labourers in one place and those in another.
Do you have any more?
The engravers board fixes the same rate as the confectionery board. And then there's a pottery board determination under which labourers are to take a minimum of 36 shillings per week of 48 hours. And I make the assumption there that pottery is a pretty heavy work. Also, there is the stonecutters board, which is, again, very heavy work indeed, and the labourers there get 40 shillings per week or 6 and 8 per day.
Thank you, Mr Parry.
If I could now take Mr Mackay to beyond wages, other entitlements that are provided to the men. Are there other such entitlements?
Certainly are. At Ballarat, we provided extended holiday leave at Christmas and also provided a contributory accident fund and a personal loan scheme for the men. These have been continued at Braybrook Junction and are under the management of worker committees.
Anything else extra provided?
Well, we also have sporting clubs. We provide for employees' social functions. More importantly, unlike the 2 witnesses we've heard today, we have built houses in the vicinity of the works to accommodate the men and their families. And others have been encouraged to build on generous terms. And I encourage my 2 workers to do the same. There they can find water and electricity. We are building stores, streets, a public hall, a library, and are planting beautiful gardens and an avenue of trees. We also have set aside land to build a technical school.
And Mr Mackay, can you tell us about the name of the township?
Certainly, something my brother and I are most proud about. The area that was located at Braybrook is now known as Sunshine, in honour of the factory.
Thank you, Mr Mackay.
Mr Doyle?
Well, Mr Mackay, you've told the court that one of your tasks is to fix wages for the factory, is that right?
Yes.
And how do you go about that?
In fixing the wages, I endeavour to get labour at the cheapest price I honestly can.
And why is that, Mr Mackay?
Until 1906, there was some deal of competition with manufacturers in America. I pay the men what they are honestly worth, both to my employer and to themselves. That is conserving my employer's interests and my men's interests.
Well, I want to take you back to the time when the factory was in Ballarat. And you're aware, aren't you, there was a wages board determination, the first determination made for the iron moulders department. Do you accept that?
Yes,
That was in 1904, do you recall?
somewhere about that date.
Now, there was a difficulty, wasn't there? Because in your factory, the board had made a determination about ratios. It had made a determination there would be one improver to every 2 journeymen. Do you recall that being determined?
I remember they made a rule to that effect, yes.
And if you'd remained in Ballarat, if your factory had kept operating out of Ballarat, you would have had to accommodate yourselves to that rule, wouldn't you?
No doubt.
So there and then you packed up and moved down to Braybrook and you opened a factory there instead.
That is not correct. There was a foundry in the Braybrook shop before we shifted the employees down from Ballarat.
Mr Mackay, the reason that the factory moved was that after moving to Braybrook, it meant you were then able to operate outside of the rule set down by the determination of the Wages Board, weren't you?
Yes.
So, Mr Mackay, you're saying, aren't you, that from that time onwards, from when you moved from Ballarat down to Braybrook, you were able to operate without complying with the determination of the Moulders Board?
We were not obliged to comply.
You did not comply, did you, Mr Mackay?
No, we did not comply.
And how long have you carried on at Braybrook without legally complying with that determination, Mr Mackay?
I believe the Wages Board determination came into force at Braybrook on the 1st of October 1906.
So from that time onwards, Braybrook was brought within the orbit of the determination and you were compelled to comply, were you not?
Yes.
So from 1904, when you went away from Ballarat, you continued to ignore the determination, you took no notice of the requirements about the ratio, right up until October 1906, when the Braybrook factory was brought within the determination. Do you accept that?
Well, I would not say we took no notice of it. We took some notice
Oh,
of
Mr
it.
Mackay, come on, you took no notice because you didn't obey it, did you?
I would not say that.
Is it not so that before the determination came into force at Braybrook, you ignored the provision as to the number of improvers set down by the determination?
Not altogether.
Oh, what do you mean by that?
We did our best to comply with it.
You did your best. Well, can I put this to you, Mr Mackay? Did you comply with it, or did you avoid it by employing more improvers than the law would have compelled you to do?
We endeavoured to comply with it.
Mr Mackay, do you swear that between 1904 and October 06 you complied with the provisions of the determination as to ratios?
No, I do not swear.
And you can't, can you, Mr Mackay? Because you know that an improver under the Act was a person under 21 unless in receipt of a special permit.
That is what I have gathered.
And you said earlier, from your point of view, there's no age limit to an improver.
I think I did.
Was that one of the reasons you left Ballarat, in order to avoid the age limit?
Well, I think the witness's previous answers effectively admit to the point, so I hardly think it's worth pressing, Ms Doyle. Perhaps if you move on.
Oh, thank you, Your Honour. Well, Mr Mackay, did you go on, as a matter of fact, and employ in your factory men over 21 without paying them the salary as a journeyman?
I believe they all had permits.
So you're saying you did not employ people who were able to do a journeyman's work and pay them less than wages of improvers?
I do not think so.
Are you aware, Mr Mackay, that the highest amount you'd be bound to pay any improver under the determination would be 25 shillings a week?
So I've heard.
Supposing then, Mr Mackay, that the men you employ as improvers, who are over 21 years of age, did not have this permit that might exempt you, would you pay them the journeyman wages of at least 8 shillings a day, or would you simply sack them?
We would have to dismiss them, no doubt.
Well, there's another alternative, isn't there, Mr Mackay, which you appear not to have considered. Perhaps you could pay them the full wages of a journeyman as they're entitled.
No, they would be dismissed. There is no alternative.
You've limited your number of improvers in the iron moulders, but then in the department where there's no wages board decisions that apply, isn't it true that you've put no limit on the number of improvers that you have?
But there is no settled limit.
Well, I've made a calculation, Mr Mackay, and based on the records that we have available here and the inquiries we've made of the workers, it appears you employ 109 journeymen, and to that, there are 179 improvers of all ages. Do you accept that?
That sounds correct.
Now, Mr Mackay, I want to take you back to the answers you gave Mr Parry about how you fix wages. Can you tell us, how do you determine whether you're going to treat a new man who comes to you looking for work as a journeyman or an improver? What test do you apply?
In the first place, he will tell us. He may say, "Oh, I can do my work very well. I'm a first-class workman." I'll ask him, "Where have you worked before? What ages or wages did you earn?" I'll ask him, "What can you do?" And questions of that nature. I'll ask if he's got any references. I may also ask if he knows anyone in the works.
Oh, and from all that information, the questions you ask Mr Mackay, you'll just make up your mind, will you, as to what he's honestly worth, to borrow some of your terminology from earlier tonight, and then you'll decide whether to offer him a journeyman's wages or an improver's wages. It's as simple as that, is it?
My apologies. If I'm satisfied with his recommendation and references, I do not make up my mind at once. I might sleep on it. I might wait a couple of nights.
Mr Mackay, is this truly the way you make yourself acquainted with the proficiency and the industry of the men who come to you looking for work?
Yes, and on the recommendation of their foreman, we fix a man's wages according to what he is worth to us.
What he is worth to you. So my question, Mr Mackay, is why don't you pay the union wages? Why won't you recognise the union rate of pay in your factory?
I pay the men honestly what they're worth. I take no notice whether a man be a union man or a non-union man.
Mr Mackay, I'm forced to ask you then, doesn't this mean you consider the union rates are more than the men are honestly worth?
I do not take the time nor trouble to inquire into union rates. If the union rates were higher than I considered the men to be honestly worth, I would not pay those rates.
Mr Mackay, you've told the court about the changes wrought around what is the area now known as Sunshine. I want to ask you a little about that. Do you really expect us to believe that these tree-lined avenues and technical schools and homes in the vicinity, these are all for the benefit of the workers, are they?
Not as such. However, we believe that married men, like you've seen today, with family and mortgage, will provide a loyal, diligent and stable workforce. However, there is no argument that we are providing an environment that is desirable for working men.
It's about controlling the workforce, isn't it, Mr Mackay? It's about keeping them close and it's about keeping them compliant so they have some sort of connection to the employer.
I do not think so.
Lastly, Mr Mackay, I'm forced to ask you this. Do you consider that because you're providing these other amenities that you've spoken of, that you should be able to pay some lower wage than your competitors who don't provide those amenities, for example?
We believe that the wages are fair and reasonable. Is it not better to employ nearly 500 men and help keep their families fed and housed at our current wages rather than the livelihood of 100 such men being lost?
It sounds like a threat, Mr Mackay. It seems to me you're suggesting you will dismiss all your workers if this court determines that you're not providing fair and reasonable wages. Is that what you're saying?
No, I'm not. But we have a business to run. Any increased cost must be met, whether it be in the increase of a price of a stripper harvester or through some reduction in the total number of men. We have to meet these costs. If we cannot remain competitive, there is a chance that all of the men may find themselves without work. What then of the families?
I have no further questions of the Commission, please.
Thank you for your evidence, Mr Mackay. Mr Parry, do you wish to proceed to closing argument?
If the court pleases, the Excise Tariff Act speaks of conditions as to the remuneration of labour that is declared by the court to be fair and reasonable. It's our position that what is fair and reasonable must take into account the position of the employees as a whole and the employer. Given the Excise Act is to protect industry for the good of all in this Commonwealth, then there is also a greater public interest at stake. The Excise Tariff Act itself is not one for wage reform. Other legislation and bodies such as the state-based wages boards are given that task of determining employees' wages. If the excise legislation is to encourage trade, the Act is to give Australian manufacturers a chance to be competitive. Part of being competitive is the reduction of costs where possible. If the excise legislation increases costs through the increase of employees' wages, it is ultimately having the opposite effect and removing manufacturers' competitive capabilities. The Act itself does not speak of a living wage. The problem with the concept of a living wage is, as we've heard today, that what is required to live varies from person to person and family to family. If all workers were to be taken as having the same financial requirements, that would be wrong. For example, what is fair or reasonable for a man without a family will not be the same as a man supporting a wife and 3 children. It is therefore reasonable to pay different workers different amounts depending on their circumstances. The need to pay a fair and reasonable amount as determined by the court ignores that an employer such as the Harvester Company will want to pay a skilled and committed employee more. He will not do so if there is a declaration of the amount needed to be paid, as he will only pay what he is legally required to do. We have heard about the movement of the factory from Ballarat to Braybrook. That is irrelevant to the assessment of what is fair and reasonable. The reasoning behind moving the factory, as Mr Mackay said, outside the Wages Board determination was largely to allow easier access to the wharves and reduce costs, and ancillary to this, there was no need to follow the iron moulders determination because it then did not apply at Braybrook. However, when the coverage reached Braybrook, the factory complied as best it could. Mr Mackay was willing and able to meet these requirements. The compliance with the iron moulders determination shows that Sunshine was paying wages seen objectively as fair and reasonable. The number of improvers is also irrelevant. By employing more improvers, there are more men employed than would otherwise be the case. That means we have 500 working men rather than 400. This improves the standard of living to a greater number of men and their families. The conduct of the Mackay Works in regard to their improvements to the Sunshine area is also relevant and should be considered in this assessment of what is fair and reasonable. It is only to be seen in a positive light as Mr Mackay is looking after the best interests of his workers and their families who live in the area. The amenities available to workers do not need to be taken advantage of by them. The workers may choose to live elsewhere, as Ms Russell did. They don't have to take advantage of the housing incentives, and they don't have to enjoy the gardens being developed. Therefore, Mr Mackay cannot be seen as trying to keep men close to work or trying to have passive control over their lives. They are simply providing options to make the workers' lives easier. An outcome that would be unfavourable to all the parties involved is if the wages are increased to a level that is not conducive with the profitability of the business. If the wages are changed to an amount that causes the business to run at a loss, all men will be out of work if the factory is required to shut down. At present, the HV Mackay factory meets the fair and reasonable remuneration set by the Excise Act. If the court pleases.
Thank you, Mr Parry. Ms Doyle?
Yes, may it please the Commission. The central question in this hearing is whether the wages paid by Mr Mackay at his Sunshine Harvester Works are fair and reasonable within the meaning of the Excise Tariff Act 1906. The unions I represent submit the only answer that can be given to this question is a resounding no. HV Mackay has not been paying fair and reasonable wages, and by his own admission, through the mouth of his own brother, has not done so because he did not think the men in his factory were honestly worth it. Worse, it's been confirmed during the evidence that the Sunshine Harvester Works moved operations from Ballarat to Braybrook in 1904, effectively to avoid the high minimum wages and the ratio imposed by the Iron Moulders Wages Board determination. There are 4 grounds the unions have presented to the hearing today. The first relates to fairness and profit sharing. The second relates to a consideration of the employer's test. Are the men honestly worth it? The third is a call for the imposition of an objective standard. And the fourth relates to the cost of living, and I'll go to each of those briefly. The first ground relates to fairness and profit sharing. In our submission, it's clear that HV Mackay has an abundant capacity to pay more to the men who work for him. While this commission was denied the capacity to interrogate the books of account in order to ascertain profit margins and costs of production for itself, it is clear that the factory has enjoyed great success, and it is only through the labour of the men employed at the factory that this has been able to occur. It's for that reason the unions I represent submit the fruits of that success ought to be shared with those who are responsible for it. In our submission, Mr Mackay and his brother have only resisted the production of the books for a cynical reason. They didn't want to throw open to scrutiny by this Commission, or much worse, the workers and the public at large, his profit margin. The second argument we've raised is a critique of the employer's test, which was stunning in its arrogance in our submission. The test was, I decide, perhaps by sleeping on it for a night or so, whether these men are honestly worth it. It's clear from the evidence given by the factory owner's brother that the employer's been approaching this important question of payment of workers by simply paying whatever he thought he could get away with. While his brother dressed this up in the witness box as a suggestion that he's always been willing to pay what people are worth, this has in reality been exposed as nothing more than an attempt to drive wages down to a bare minimum, or what the employer can get away with, or perhaps get away with by enticing workers onto the payroll by speaking to them of amenities, such as housing available in the vicinity, or the fact that a school is being built. Now, I'm forced to recall that it was in the course of part of this evidence that Your Honour, the President, was prompted to remark from the bench, I'm not going to accept the final word of an employer on an employee's worth in wages any more than I would accept the value of a horse on the word of a vendor. Now, that is my note of what Your Honour said on one of the days of argument. This callous likening of workers to horses, or horses being purchased at auction, is very revealing, in fact, in our submission. It discloses the reality that Mr Mackay and his brother have exhibited no understanding, much less any sympathy, for the plight of those forced to work for so little, as was powerfully demonstrated in the very poignant evidence of Mr Keating and Mrs Russell. The unions submit that if Parliament had intended the question of wages to be left to what people like Mr Mackay can get away with, or on a comfortable night's rest in their palatial homes in Toorak regard as fair and reasonable, then it would not have even bothered to insert those words in the Act. The union implores the bench not to succumb to the free market approach. This will only necessitate a race to the bottom. The third argument I've identified is the objective standard. The third argument the unions advance is that there should be some objective analysis and then some comparison of the skill exercised and the nature of work performed by each man. We implore the bench, when fixing a fair and reasonable wage, to take into account whether the work done occupies long hours, for example, whether it's unpleasant, whether it's difficult and exposes the worker to muscular strain. And there must also be a focus on the skill and experience required to perform the labour. Something more than Mr Mackay sleeping on it is required. There should be some acknowledgement made of skill, years spent honing that skill, and also the burden of undertaking difficult, dangerous and even monotonous work. To that end, the court has heard evidence from a number of trades, including iron moulders, blacksmiths, woodworkers, wood machinists, painters, improvers and journeymen in all of those fields. We ask the bench to set a rate of pay according to objective criteria, weighing the factors I've mentioned, and then perhaps transpose those wages into some sort of scale. I know not what it might be called in the future, perhaps an award, perhaps a certified agreement, perhaps an enterprise bargaining agreement. And then in the future, those who come after us might be able to look at those documents, perhaps visit the court and look at them there, and would be able to ascertain at any point in time what a worker who possessed that list of skills and experience ought to be paid. We ask that this happen, and perhaps even then the standard could be updated. I know not how often, perhaps every 4 years or so, we could modernise those standards. And then one would always know what is a fair and reasonable rate for a blacksmith of 2 years' experience, or for a wood machinist with 10 years' experience. All of that information would be available and able to be gathered. The final submission the unions make relates to the cost of living. And we say that the fair and reasonable wage that should emanate from this commission could only be one fixed in relation to and higher than the current cost of living. Now, I must confess that when we prepared our case, we came here prepared to argue the first three arguments I've put today, and perhaps not the first, but at the bench's urging and accepting that the ideas that come from the bench are always the best ideas, we've been as nimble as we can and called on the workers who were here, showing their interest in the proceedings, and their wives, who gave evidence at short notice about the expense of living in the state of Victoria. The court has now heard from 14 witnesses. There were 11 male workers and 3 of their wives, including Mr. Frederick Keating and Mrs. Mary Russell. Now, what more powerful display could you have than the evidence of these 2 witnesses? The misery of the life of Mr. Keating. No football and no beer, it appears, since the birth of his 5th child. And you could not but admire the evidence of Mrs. Russell. No one knows better than Mrs. Russell the scrimping and the saving required in order to make ends meet and to keep her household functioning. You've also heard other evidence. You've heard from a Collingwood real estate agent concerning the cost of renting a house suitable for a large family, and a Paran wood and coal merchant who gave evidence about the average price of heating homes in Victoria. We submit that the best evidence you have heard is that evidence directed to the cost of living, the evidence of workers and their wives who scrimp and save in order to house, clothe and feed their families. We do wonder, perhaps in the future there might be some other means of ascertaining the price of things more generally across Victoria, or I'd venture even further across the other states. It might be theoretically possible that in the future the Commission might be able to inform itself having regard to some sort of central collection of information. For example, that information might tell us what it costs to buy meat, or coal, or shoes for a husband and children. Perhaps one day in the future all that information will be collected by some record keeper and published for each to consult whenever they need to know the cost of living from time to time. We know not who or what might be capable of this Herculean task, but we live in hope of a method, or even a machine might be one day developed in order to house such information. We accept it will take a miracle of science. We suspect it may take an even greater miracle, possibly in the nature of divine intervention for another change to take place in the future. We accept that this is nothing more than a fantasy, but having heard evidence such as that from Mrs. Russell and other women who appeared before you, we wonder whether even in the future this Commission might entertain looking at the wages paid to women in employment. If that happened, the Commission might inquire why such a low value is placed on sewing, such as taken in by Mr. Frederick Keating's wife, or the work often performed by women of cooking and cleaning and caring for other people's children, or looking after the infirm. As I say, it would require a miracle, perhaps divine intervention. But if the court were willing to look at that, we wonder whether it might go even further and hear more detailed evidence about the unpaid work done by women in the home, caring for children and the infirm and the elderly, and then perhaps place some value on it. We do not know whether, assisted by that sort of evidence in the future, there might be an inquiry into whether the wages paid and not paid to women are fair and reasonable. But until that time, we assume that the best we can hope for is that this Commission address the pitiful wages paid to male labourers, including at the Sunshine Harvester Works. And for that reason, we call on the Commission to ensure a reasonable wage is fixed, one which is fair and reasonable within the meaning of the Excise Act. Perhaps then, by sheer force of that injustice being addressed, for the men of Braybrook, one day their wives and daughters might dare to hope for the same. May it please the Commission.
Thank you, Ms Doyle. After considering the evidence presented to him, Justice Higgins decided that Mr Mackay was not paying a fair and reasonable wage to his unskilled employees. There's a copy of the judgment in the material that's been provided to you. His Honour determined that for the Sunshine Harvester Factory to receive tariff protection, Mr Mackay would have to pay his unskilled workers 7 shillings a day. You'll see from your own reading of the judgment that there's little indication as to how His Honour came about this amount. The evidence was presented over 20 days. There were a number of witnesses called. And the judgment affected the employees of one entity only. The Fair Work Commission is the successor body to the Commonwealth Court of Conciliation and Arbitration that determined the Harvester case. There have been many changes in name and in jurisdiction and the manner in which the tribunal operates over that time. But the common thread between then and now has been the fixation of minimum wages and the complexity involved in that task. If you look back to 1907, the court at that time dealt with 2 cases. In the last year, the tribunal dealt with over 16,000 hearings. It currently has 44 members, over a third are women. There were no female members for much of the Court of Conciliation and Arbitration's existence. In 1907, the judges of the court wore wigs and gowns. They dealt primarily with collective disputes. The tribunal now deals with a range of collective and individual disputes, including unfair dismissals and anti-bullying applications. Today, the annual wage review is conducted by what's referred to as the expert panel, which consists of the President and 3 other full-time Commission members and 3 part-time members. The statutory provisions today are very different from those at the time of the Harvester case. In each annual wage review, which reviews the national minimum wage and modern award minimum wages, the panel takes into account various statutory considerations. Among those are relative living standards and the needs of the low paid, the performance and competitiveness of the national economy, and the impact of increases in the national minimum wage and award wages on employment. Last year, the Commission received submissions from 28 parties, including the Australian and several state governments, peak employer and employee bodies. The Harvester case directly affected the wages of 31 employees. Annual wage decisions currently directly affect about 1.9 million employees across Australia. The Harvester decision totalled about 25 pages. The most recent annual wage review ran to a couple of hundred with over 300 footnotes, perhaps a sign of the times. The Act that governed the court's operations went to about 26 pages, including a schedule. The current level of legislative regulation governing the tribunal's operations runs into many thousands of pages. But one thing that has remained constant is that the basic issues discussed in the Harvester case have echoed over time. The idea of employers paying employees a fair and reasonable wage still resonates today, even if the statutory framework is different. The Commission still seeks to balance relative living standards and the needs of the low paid with the economic impact of its decisions, particularly on employment. We hope you've enjoyed Harvester Revisited, and we thank you for joining us for this event. We're pleased to have with us in the audience tonight some direct descendants of H.V. Mackay, Sam Hunt and his father Robin. Sam is the current chair of the Sunshine Foundation Charitable Trust, set up after the passing of H.V. Mackay in 1926. We're also pleased to have with us former Commission President Jeff Judici, Emeritus Professor Joe Isaac, I'm very pleased to see here this evening, Professor Keith Hancock and Professor Sue Richardson. I should have mentioned that Professor Isaac and Professor Hancock are former members of the tribunal. And in addition, we have a number of current and former judges of both the Federal and Supreme Court. I just wanted to conclude by thanking some of the people who've assisted in making tonight's event possible. I'd firstly like to thank Chief Justice Marilyn Warren and the staff of the Supreme Court for their assistance in helping us hold this event in this historic Banco Court. To our representatives, Rachel Doyle and Frank Parry, who have both taken the time out of their very busy professional lives to be involved with Harvester Revisited and in demonstrating some exceptional advocacy skills. And we have a small token of our appreciation for them. To our witnesses, Lee Chambers, Catherine Luby and Paul Hollywood Guilfoyle, who has been a regular actor in, I think, all of the moots that I've been involved in. And their understudies, Martin Wagner and Pamela Hyde, who have helped bring this historic event back to life. To Keith Hancock, who was the principal consultant for the scripting of the event, and Deputy President Reg Hamilton for his assistance with the source material and for recording the event opening. I'd also like to thank all of the staff of the Commission who've been involved in writing, preparing and assisting with the event tonight, particularly Kate Purcell and Lauren Mathis for coordinating the event, Michael Holland for all of his work in the research and scripting of the event, Liz Leong for organising the logistics and the costumes, which you'll have to return at the end of the evening. And to the rest of the Commission's engagement team who've been working to bring this event to a successful conclusion for the past 6 months. I'd also like to thank Claire MacDonald for her work with the introductory video and for taking the photos tonight. We've also had many volunteers assisting us here this evening from the Commission, the Supreme Court and the Victorian Law Foundation. And my thanks to all of you for your attendance, and good night. Adjourn the proceeding.